number one complaint that people have at the end of the year when they're filling out the evaluation forms. And I should pass along to you that for those of you who weren't involved in the past, we have a rule. It was 2.2, and then it was 2.3, where if a judge makes a determination that a witness testified about things that were outside the scope of the affidavit and would materially affect the outcome of the case, he could penalize, each performance judge would penalize that school by a point. And the frustration there was sometimes you'd have a judge say that's out of scope, but there's no point deduction. We're going to do a half point, or there is a 1 point, and you think it's a picky little thing, and you're trying to figure out what the heck is going on here, and there's so much inconsistency there. That was frustrating. Now, in real life, there's no such thing as a scope objection. We don't have it. So one of the disadvantages would be if we have a new attorney coach coming in to try to help out a school, and they want to do a good job helping this school out for the first, their first time, how the heck do they understand and explain this scope objection to these students when they never used it in real life? The other thing is, we don't have scope deductions at the national competition. They don't have scope deductions in college mock trial, and they don't have scope penalties in law school mock trial. And my kids have gone through the high school, college, and law school mock trial programs. So I've watched and I've judged on all of them. So we had a rule that was unique here that wasn't being used at nationals, wasn't being used when they go to college, and wasn't being used if they went to law school. And it gave an advantage to people like me who've been doing this for 10 years, and I can tell my students how to do it this way or that way to try to avoid getting the deduction. And so we said, you know what, let's just level the playing field here. Let's eliminate that point deduction. And now what you have to do is what everyone else has to do in real life, or what they do in college and in law school competitions, and that is learn how to impeach the witness. You're going to have to teach your attorneys how to point out for the performance judges that this witness has just made up a fact. Okay? And if you look at the rule 2.2, which is there, 2.3 is gone. 2.2 says, if a witness testifies outside the facts in the witness statement, the witness may be impeached on cross-examination. Scoring judges will take into account in their scoring whether a witness has testified to facts not in the witness statement. So Chuddy said that we're going to advise the regional directors to instruct the performance judges that when they see witnesses making up facts, that they should take that into account when they score the witness. And that's what they do at nationals, that's what they do at college. That's what they do in law school. And that's really what happens when a jury is judging a witness in real life when I try a case. So I think this is a good thing. We're going to reevaluate that rule. The advisory committee is going to reevaluate the rule at the end of the year, see if it works the way we're doing it this year. But if you're an attorney, you need to take the time to teach your attorneys to be able to cross-examine a witness about asking what was in the affidavit, whether that piece of information that they just disclosed was in fact in the affidavit or not in the affidavit, implying that they're making up evidence so that the performance judges can score that witness down for doing that. And hopefully what's going to happen here is we're going to avoid the complaints about inconsistencies between presiding judges in this courtroom and that courtroom, and not knowing what's happening. And I think it's a good thing. I think it'll be better for the program. So we've got about 10 more minutes now, and we wanted to leave time for people to be able to ask questions, and Janelle and I will just answer as a panel from our individual perspectives.
One thing I struggle with, I strongly believe that the kids should develop their themes, they should develop their questions, and so we use the Socratic method. We'll get an idea from them and then try and help them through questions, kind of think that through.
But there are times when the problem set is very difficult. The Carlton Armstrong pardon was one of them. All of our kids felt strongly that he should not be pardoned, and they had a real problem trying to figure out why he should be. There were wonderful materials. There was the Declaration of Independence that said you have a duty under certain circumstances. And tried to open that up through questions to kind of give them some idea. But I wasn't willing to go to the point of saying, okay, you could put these together. But usually it's not a problem. But with a real difficult case material like that, how far do you go?
Well, we had the unlucky draw, and we were up against Rhinelander in the finals before the Supreme Court, and Xavier had to argue that Carlton Armstrong should be pardoned, and so I sympathize with that fact situation. But really, what we're doing is we're trying to get the kids to think like lawyers, I believe as a lawyer, even though I'm a personal injury lawyer, I don't do criminal defense work, but I believe that you have to believe in the system. If you have one side laying over and playing dead and the other side prosecuting vigorously, then the decision maker, whether it's a jury or a judge, can't make a fair decision. It's not my job as the prosecutor to litigate all the defenses of the defendant, nor is it my job as a defense lawyer to point out to the jury all the things that the prosecutor should have argued. If we're each playing the role of being advocates for our respective positions, we have to trust that our justice system is going to give us the right result, whether it be a judge on sentencing, whether it be a panel who's deciding on a pardon, whether it's a jury. We have to trust the system. So you have to teach your kids that they are not the ones who are making the decision. They're arguing vigorously on behalf of their client to allow the system to work. Now, if in that case, there are certain things that you can point out that are weaknesses in the prosecution's case. There were certain things that would be positives, certain things that were societal things, and our kids brought into the societal issues at the time, because it was a very broad case about what was going on in society at the time. That was the 60s, and people thought differently, and you have to analyze their conduct in light of the way people thought in the 60s. And if you take a step back, yes, you can do those things. Do we as coaches need to help them with that process? Absolutely. Because the kids have never done that before. We need to give them guidance. And we tell them to in this case, you might want to analyze it in a very detailed way. This one, you might want to take a step back and look at it globally. You guys, but you're helping them decide different ways to do it. You can do it this way, you can do it this way. What are you guys interested in doing? I shouldn't say guys, the girls and guys interested in doing. What approach do you want to take? And then what you'll find is, as smart as I think I am, I don't want to pat myself on the back or anything like that. I'm just trying to be facetious about this. A lot of the kids will think of things that I had no clue were in the materials. They're going, oh my gosh, did you see this? And did you see this? And you're going, whoa. Yeah, and they pick out things that I haven't thought of. They take ownership into this thing, and once they understand that they're trying to develop a theme, you'll be amazed at how smart those kids are and how they can help develop facts to be proponents of the themes. But yes, we got to give them some guidance as to explain to him how they go about doing that. Does that help you?
It was just when you said that you wanted to have, give them different ideas of how the case might go. Would you have gone far enough in that situation to say, okay, you could consider prosecuting it on this theory, or you could consider taking kind of a radical approach and looking in that case about why society would be good for society for him to be pardoned, because they just really struggled with that idea. and then say, okay, you choose, or if you have other ideas. Because I just, as much as I wanted to, I just didn't want to say, okay, here are the key components of this. This is why it would, might be argued to be good for society. I tried hard to encourage them, to come up with those ideas and pointed out different things in the case, but they just really struggled with it, and short of me laying out the theme, they couldn't get there.
I think you have to let the kids try it. I think you have to let them. That's one of my biggest complaints. Sometimes is I feel like we try the case before the case goes to trial, and I think you work. Kevin said it beautifully. If you trust the system, if you trust that we have a program that's good and that the case writers are thoughtful, and if you trust that your kids are working hard, then they're going to try the best case that they can. And not every year is a year for you to go to state or for you to perform in the top 5 or whatever your goal is. But I just think they have to try the case they create, that they know to try, and we have to really fight sometimes to pull ourselves back a little bit, so that we're not too much in there, because also they're not going to feel it passionately if it's something I've tried. If I teenagers, if you try to tell them to do it, that's exactly what they're not going to want to do. So sometimes it helps if you just sort of step back and, like you said, using Socratic method is really good, because asking them to think about things in a different way. So that would be my thought.
And the scrimmages are so helpful in that regard, because they'll have an idea, they'll see it, and they're thinking, this isn't working. And then they can take a step back and reevaluate where they're at, and then change things. We tell the kids that don't think that the set of questions that you just prepared is going to be anything close to what you're going to have later on. And they go through scripts of questions and answers, revisions, all the way to the day before regionals, the day before state, and we're making changes in the middle. And if you're going to be good and be able to adapt, the kids have to really understand those materials. Otherwise, when you're talking about making changes, they won't have a clue what you're talking about. They have to. We're of no help once that trial starts. We're behind that bar there, and they have to think on their own. And if they haven't been taught to do that up until then, they just can't respond well and do a good job. So they have to take ownership of their theme. And yeah, we do have to give them some guidance, kind of push them. If we think their ideas just really the facts are not going to support what they're trying to do, yes, we need to sit down with them and say, do you think this might work because of this or this? You might get hammered when you try to you're being cross-examined to your expert on this theory. So we have to guide them. But I really think that if we lay out their themes and lay out their scripts, they'll go so far, but they're not going to go beyond that.
Thank you.
What do you think, Kathy?
I think that it's important to have input from the students.
Kathy, just a minute, can you wait till the mic comes over? Thanks.
I think it's important to have input from the students so that they have some ownership in the process, and I do think they understand it a lot better if they are the originator of the idea. We try it in practices against ourselves. We have 2 teams.